Right. And obviously the big one that we just got a decision in is Duncan v. Bonta, which was the case against the 10-round limit that California places on magazine capacity.
Yes.
Now, this was sort of a retread, I guess. We had this was District Judge Roger Benitez who issued this ruling, and it's very similar to the ruling that he issued along the same lines a few years ago. But after that, a panel agreed with him effectively and ruled against.
Three-judge panel in the Ninth Circuit agreed that it was unconstitutional under Heller.
Right.
Before Bruin came down, it went en banc. The en banc panel, in a split decision, said no, the magazine capacity limitation is constitutional. We took it to the United States Supreme Court. This was before Bruin came down. The Supreme Court held it. Then after they issued Bruin, they did what's called a GVR, a grant review, vacate the lower court decision, and remand the case back down to the lower court for reconsideration in light of what they had said in Bruin. And so it went from the Supreme Court back down to the en banc panel. Then the en banc panel sent it back down to Judge Benitez to apply the Bruin analysis that had theoretically, at least, although states try and twist it, it clarified a lot of the things that Heller had said, but had been misinterpreted by the courts. And so this is the first decision that's come out of Judge Benitez of 4 cases pending in front of him. And they were all kind of backed up behind Duncan in the Ninth Circuit. And then they were all remanded back down to Benitez too. So we've got the magazine capacity limitation. We've got an assault weapon challenge. There's actually 2. CRPA has RUP. And then there's the Miller one in front of Benitez, which I wouldn't be surprised if we see a ruling on that. We might see a ruling on one of these other 3 cases tomorrow. And then there's the CRPA's Rohde case. That's Kim Rohde, the Olympic sporting clay shooter that we all should know and love.
Right.
And then
one of the most successful Olympians in history, right?
Yes. And then there's a challenge to the California Billy Club ban, which is also pending in front of Judge Benitez. I think we're going to see 3 wins on all of those because the judge just gave them every opportunity to put as many historical laws into the record as they wanted to. He gave them multiple briefing opportunities, multiple research opportunities. They submitted a stack of pages of all these irrelevant historical laws. Remember, under Bruin, the test is it covered by the language of the Second Amendment itself, keep and bear arms? And then if it is, and most things are, most bearable arms at least are, then is there a historical law that would compare to the current law that would indicate that the founding fathers in 1791 would have tolerated the modern day law back then? So it's like a legislative intent analysis. What was the purpose behind the Second Amendment when it was passed, and what kind of infringements were tolerated then that would indicate that those kinds of infringements might be tolerated today? So that test, that methodology, is the big fight that's going on in the Ninth Circuit right now. Obviously, we all care about magazine limitations. We all care about semi-autos. We care about other arms, whether knives or billies or whatever. And we care about ammo, background checks. There's all these different kinds of restrictions that the state has stacked up on us over the last couple of decades. But the real question is going to be, and the real difference is going to be made by whether or not the Ninth Circuit in particular, applies Bruin faithfully, the way the Supreme Court intended it to be applied. And they're already twisting that, for example, in the magazine case, they tried to say magazines are not arms. So you have a right to keep and bear arms, but magazines are not arms, so they're not covered. Well, that's not what the Second Amendment, it's not literally only applying to the one, a particular type of firearm or other arm. It's about all the ancillary activities, the parts. There's no right to keep and bear a trigger either, but you can't have a gun without a trigger. You can't have a gun without a barrel. All those parts are part of the arm. And not only that, going to the range, taking your gun in for repair, taking part in competitive or recreational shooting activities, that's all part, hunting, That's all part of the Second Amendment's protections. And they want to try and narrow it as much as they possibly can, to basically make Bruin not mean anything. So that's the fight we're having right now, is whether or not the test is being applied properly.
Sure, yeah. And you've seen other judges in the Ninth Circuit take up this arms reasoning of, you just had the Washington State magazine limit case came down in the opposite direction that Duncan did. But, and so, yeah, it's going to be, sure seems like it's going to be a continuing fight. But Duncan in particular is fairly important because it is, as you mentioned, one of the 4 cases that the Supreme Court specifically GVR'd. And so, that tells us something about what the court is perhaps watching closely. I think Young v. Hawaii, right? That was one of the other ones, and that's already been settled with Hawaii.
Right.
So that one's kind of off the table. You still have the assault weapons ban case in Maryland that hasn't,
Right.
that's kind of just sitting there.
It's been sitting there since December. We're really waiting for that one to come down.
Right. And then I believe there was New Jersey's magazine ban case as well, which is also sitting last that I recall on that. And so Duncan is kind of the first one to see really significant action, getting a ruling from a district court judge that one is favorable to what you guys want, right? I mean, first off, just tell us what did Benitez find? What was his reasoning?
He said magazines are arms, and so they are covered by the text of the Second Amendment, and they are in common use. And Heller tells us that people get a little confused about what the common use test is. There is, strictly speaking, there is no common use test. There's a historical analog test. And in Heller, remember, Heller was the gun ban test,
Right.
banning handguns in the home, which meant basically banning them everywhere in Washington, D.C. And then Bruin was licensing to carry them in public. They weren't banning any particular handgun. They were just restricting your right to carry one in public for self-defense. But so under Heller, the court did this analysis under the historical analog approach.
The common use, yeah.
But it said there is no historical law that bans firearms that are in common use for lawful purposes. So it's common use is not, it's become a shorthand, but it's really not. There's no common use test. There's a historical analog test that says, and Heller says, if it's in common use for lawful purposes, there is no historical law that ever banned firearms that were in common use for lawful purposes. The only laws that have historically existed were bans of dangerous and, not or, dangerous and unusual weapons, or regulated the manner of carry. You can't carry them into certain bars or whatever the laws used to be that would say where you could have a gun, or if someone was misbehaving, they would require them to put up a bond in order to be able to keep possessing a firearm. They never wholesale took all the guns away from any class of people. So that's really where the fight is. But Judge Benitez said, these are probably one of the most common things possessed by firearms owners. There's millions of them, millions and millions. So you can't just ban them. And he also, this is a 71-page beautiful opinion that's extensively documented. I mean, it's half footnotes. He knows he's going to be appealed. So he made sure to document everything so that the Court of Appeals is going to have a hard time overturning it. But he said, these are common. The state can't arbitrarily decide that 10 rounds is all you need for self-defense. Who is the state to say how much, to ration your ability to defend yourself that way? So it really, it's a beautiful opinion. He said there's no historical analog to banning gun parts like this. And so it fails the Bruin test, and it's unconstitutional. So it's a great ruling in multiple respects because it's so thorough, and also because he applied the Bruin test right. He applied it the way it's supposed to be applied. And the only other case that's done that so far in the Ninth Circuit is the Tedder case, the butterfly knife case out of Hawaii, where a Ninth Circuit 3-judge panel applied the methodology correctly from Bruin. So some of these courts have been buying into the state's arguments that, magazines aren't arms, or that some historical Bowie knife restriction is an analogous historical law to the modern day ban on magazines or semi-autos or whatever it is. They're really grasping to try and justify a law with those kinds of flimsy historical analogs. And so sooner or later, the Supreme Court is either a circuit court, and hopefully there will be a consensus, starting probably with the Ninth Circuit, or the Supreme Court will have to get in there and say, you guys read Heller wrong for 12 years, and now you're reading Bruin wrong. And here's what we meant when we said this, that, and the other thing in the Bruin decision. So now get it right from here on out.